Good day. My name is Akim Olajide Bello from the Faculty of Law, University of Lagos. This lecture is on the concept of criminal responsibility, meaning and content. It's one of the lectures that is part of our Masters of Laws LLM at the Faculty of Law. So today I'll take us through this presentation, which is on criminal responsibility, meaning and content. The learning objectives of this presentation is as follows. This lecture examines the meaning of the concept of criminal responsibility and its content. At the end of the lecture, students should understand the meaning of the concept of criminal responsibility and the content of criminal responsibility. What are the learning outcomes? At the end of the lesson, we expect that the students should be able to explain the meaning of the concept of criminal responsibility and also the content of criminal responsibility. Those are the two things that we expect that the students will be able to do at the end of the presentation. The concept of criminal responsibility. We know that the criminal law imposes sanctions for violation of its provision. That's one of the unique features of criminal law legislations. The law prohibits a conduct or an omission, and it imposes sanctions for violation of the provisions. Now, the finding of guilt and the imposition of sanctions depends on whether a defendant should be held liable and punished for the offense. If a defendant is found guilty, the question of the imposition of sanction depends on whether a defendant should be held liable and punished for the offense. Section 1.1 of the Criminal Code defines the terms criminally responsible to mean liable to punishment as for an offense. The term criminally responsible is defined in Section 1.1 of the Criminal Code to mean liable to punishment as for an offense, while the term criminal responsibility is defined to mean liability to punishment as for an offense. Liability to punishment as for an offense. So what do we mean when we say a person is responsible? What do we mean when we say a person is liable to punishment, or a person's conduct should attract liability for punishment? So what do we mean when we say a person is responsible? Ronald Leifer argues that when we say a person is responsible, we are not describing their behavior. We are assessing it either favorably or unfavorably. Now, the offender has done something that contravenes the provisions of the criminal law. When we are dealing with the question of responsibility, we are not describing the behavior of the offender, the conduct of the offender. What we are doing is we are assessing the conduct of the offender and making a determination, favorably or unfavorably, as to whether that offender should be punished for that offense. We are assessing their conduct either favorably or unfavorably. If we assess their conduct favorably, in other words, if we assess that, well, they have committed the act, but there are some mitigating circumstances, or there are some circumstances that provides a justification for the conduct, then we can reach the conclusion that the defendant should not be punished for the offense. The rules which are used to assess a criminal conduct and determine whether they should be assessed favorably or negatively in terms of guilt and punishment are set by the criminal law. Now, the criminal law sets out rules which provides a basis for assessing a criminal conduct and the determination of whether that conduct should attract guilt and punishment. So if using the rules, we assess that the conduct should attract guilt and punishment, then we would then come to the conclusion that the defendant should be held responsible. The defendant should be held blamable for the conduct. The rules of criminal law, which outlines the basis for assessing behavior and determine whether it should be favorably or unfavorably assessed for the purpose of guilt and punishment, are contained in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code. Now, generally, the other provisions of the code creating specific offenses defines the prohibited conduct or omission. But they don't provide the rules that helps us to assess the conduct of the defendant in terms of guilt and punishment. So the rules governing the assessment of the conduct of the defendant for the purpose of determining the guilt and the punishment of the offenders are also rules of criminal law that are different from the provisions of the criminal law defining the specific offenses. And these rules that provides a basis for assessing the conduct of the offender are contained in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code. It is the rules contained in this chapter that provides a basis of assessment for determining the guilt and the punishment of the offender, for assessing favorably or unfavorably whether the offender deserves to be found guilty and consequently punished for the offense, or whether the offender does not deserve to be found guilty and punished for the offense. So these rules are contained in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code. And these rules, they are part of what we call the general part of the criminal law, PATH, the general part of the criminal law. They are general provisions that applies to all offenses, irrespective to the type of offense that may be created by the provisions of the law. These rules, which formed a component part of the criminal law, is what we refer to as, the general part, the general principles that govern criminal liability. And like I've said earlier, they are to be found in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code. The rules that we find in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code incorporate the idea of no liability without fault. So what the rules generally tries to achieve is that a person, although has done the prohibited act or has made the prohibited omission, may not be held liable, may not be found guilty and liable to punishment if there is no fault attributable to his conduct. The rules incorporate the idea of no liability without fault. The rule says that a person should not be held liable for a crime unless some measure of fault can be attributed to him in carrying out the conduct or in making the omission. Where there is a positive assessment of his conduct within the provisions of the rule, then there will be no liability. Where there is a negative assessment, then liability and punishment will attach. The offender will be found guilty and will be liable to be punished. Now, generally, the rules are found in Chapter 5 of the Criminal Code and Chapter 2 of the Penal Code. But the key sections, the main sections in the Criminal Code are Sections 24 and Section 25. While under the Penal Code, they are Sections 45 and 48. In the criminal code, there are sections 24 and section 25, while under the penal code, there are sections 45 and section 48. So you can check those provisions. Section 24 essentially is the one that says, subject to the express provisions of this code relating to negligent acts or omission, a person is not responsible for an act or omission which occurs independently of the exercise of his will of an event which occurs by accident. Section 25 is a provision that provides for a defense of mistake of fact. If a defendant commits an offense under a mistaken belief in the existence of a state of fact, then the law will excuse him from liability. Now, the essence of sections 24 and section 25 is to create grounds of fault. Grounds of fault. A defendant whose conduct cannot be, fixed within the provisions of section 24 and section 25, or a defendant whose conduct is favorably assessed within the provisions of section 24 and section 25, has no fault element. And because he has no fault element, he cannot be found guilty of an offense, and he cannot be punished for that offense, even although he may have done the prohibited act, or he may have done the prohibited act or made the prohibited omission under the law. The equivalents of section 24 and 25 under the criminal code are the provisions of section 45 and 48 of the penal code. Section 24 of the Criminal Code Act make the provisions of chapter 5 of the criminal code apply in relation to all offenses under any act, law, or statute to all persons. So what section 24 of the Criminal Code Act does is to say that the provisions of chapter 5 of the criminal code, these provisions that governs the question of criminal responsibility, these provisions apply in relation to all offenses under any act, law, or statute. So what that means is that the provisions of chapter 5 of the criminal code are general principles of criminal liability which applies to all offenses under the code, all offenses under any act, all offenses under any law, and all offenses under any statute. You know, I said earlier that the provisions of chapter 5 constitutes what we call the general part of the criminal law, PATH. The general part in the sense that these are general principles that applies to all offenses, irrespective of the kind of offense that they may be. Okay, now, there is no equivalent provision similar to section 24 of the criminal code under the penal code. But chapter 2 of the penal code arguably also applies to all offenses, because the penal code is the general criminal law. And as it is a general criminal law, it provides general principles of criminal responsibility under its own chapter 2. And those general principles of criminal responsibility applies to all offenses under the criminal code. And there is no reason why they should not apply to all offenses under any other law creating offenses, unless, of course, there is a specific provision under that law that excludes the application of chapter 2 of the penal code. We should also note that under the Sharia penal codes applicable in most of the northern states, there is also a chapter 2 governing criminal responsibility. So we have looked at the meaning of criminal responsibility. Now we want to examine the content of criminal responsibility. The content of criminal responsibility can be divided into two generally: the basis of criminal liability and the defenses that negative criminal liability. The basis of criminal liability and the defenses that negative criminal liability. Now, the basis of criminal liability is premised on the concept of no liability without fault. I've explained that earlier. It is a general principle in criminal law that a person is generally not responsible for an offense unless some measure of fault can be attributed to his conduct. If there is no measure of fault that can be attributed to his conduct, then he may not be liable for that offense. And we have said that the rule that provides basis for determining liability based on fault are contained in Chapter 5 of the Criminal Code and in Chapter 2 of the Penal Code. Now, under English criminal law, the concept of no liability without fault is expressed in the concept of mens rea. And mens rea is often expressed in the Latin maxim actus non facit reum nisi mens sit rea. And this is interpreted generally to mean that an act does not make a man guilty unless his mind is guilty. So the guilty mind there is one instance of fault which provides a basis for liability, for criminal liability. Three meanings have been ascribed to mens rea. And the first is the conception of mens rea as a subjective mental element of an offense in relation to the definition of an offense. The concept of mens rea, that's the first meaning, as a subjective mental element of an offense in relation to the definition of an offense. The subjective mental fault. The second meaning is emphasis on historical requirement of intentional conduct. The choosing to do harm coupled with the foresight of harm as a basis of common law of crime. Now, the first one deals with the subjective mental element of an offense in relation to the definition of an offense. The subjective mental element there may be, intention to do the act or make the omission. And the intention may take various forms. For instance, it may take the form of a fraudulent intention. Okay, that's a subjective mental element. Now, the second meaning is the emphasis on historical requirement of intentional conduct, which encompassing choosing to do harm, coupled with the foresight of harm as a basis of common law of crimes. Under the common law of crime, there is a historical requirement of intentional conduct. And that intentional conduct is explained in terms of the offender having a choice and he has chosen to cause harm. Not only that, he has chosen to cause harm with a foresight that harm is likely to ensue from its conduct. So that is the second sense in which the term mens rea is used as common law. Now, the third meaning of mens rea is a normative approach. In this third sense, mens rea is used simply as a compendium of expression for the varieties of fault that may give rise to criminal liability. So here, it's not only concerned with the subjective mental element, it's not only concerned with the historical requirement of intentional conduct, but it's wider. It takes a normative approach by having an umbrella expression that reflects a variety of faults. So the faults here need not only be subjective mental element, need not only be intentional conduct. It could also be other forms of fault that the law has defined, which is not necessarily a subjective mental element and which is not necessarily an intentional conduct. Mens rea in the first and second sense will include intention, recklessness, knowledge, when the law requires that you have done an act with a requisite knowledge. For instance, the offense of receiving stolen property, knowing the goods to have been stolen, belief, dishonesty, etc., as a fault element necessary for criminal liability. Mens rea in the third sense include liability based on negligence. You know, we have said that in the third sense, it's a compendium of varieties of fault elements. One of the fault elements which provides a basis for criminal liability is negligence, and also in situations of crimes of strict liability. In crimes of negligence, what the law does is to impose a standard. And when the defendant's conduct falls below the standard, an offense is committed, irrespective of the defendant's state of mind. You know, here, the law is not concerned with whether the defendant did the act intentionally or recklessly or with knowledge. What the law does is the law sets a standard. So once the conduct of the defendant falls below that standard, that is a fault element that is required for criminal liability. Okay? The fault in crimes of strict liability is the doing of the prohibited act, the doing of the prohibited conduct, or the making the prohibited omission. The mental element in terms of subjective mental element or intention is irrelevant. Now, when we are talking of strict liability offenses, the first element is that the law says something should not be done. The law is not interested in your subjective mental state when you did the act. The law is not interested in the historical requirement of intentional conduct. All the law is saying is that this must not be done. And once the conduct of the offender falls within the legal prohibition, then an offense is committed. In Nigeria, under both the criminal and the penal code, fault as a basis of liability must be determined in accordance with the provisions of the codes and not the principles of English law. This is very, very important. This is very, very important. And it's important because we have a code-based system of criminal law. Our criminal law in Nigeria is codified, either in terms of the provisions of the criminal code that applies in southern Nigeria, or in terms of the provisions of the penal code that applies in northern Nigeria. So when we come to determining the question of the question of the basis of criminal responsibility in Nigeria, we must have recourse to the provisions of the codes and not to the principles of English law. Okoko and Nash argue that in Nigeria, the source of the principle of no liability without fault is Chapter 5 of the Criminal Code. And that sections 24 and 25 of the Criminal Code are the principal sections. Okay? I've made reference to section 24 and 25 earlier. These are the section, Chapter 5 generally of the Penal Code deals with the principles of no, all the provisions, you know, encompass the principles of no liability without fault. But sections 25 and 24 and 25 are significant. Those are the main provisions. Okay? Now, similarly, the provisions that governs the principle of no liability without fault under the Penal Code are the provisions of Chapter 2 of the Penal Code. And again, the principal sections are sections 45 and sections 48. The need to rely on the provisions of the Criminal Code for determining criminal responsibility and not the doctrine of mens rea was stressed in the Queensland case of Thomas versus Makita. Now, of course, you know that the criminal code that we operate in southern Nigeria is substantially similar to the criminal code that they operate in the state of Queensland, in Queensland, Australia. So, most of the provisions under the Queensland Code are similar, almost verbatim with the provisions we have in the criminal code that operates in southern Nigeria. And in interpreting that code, the court has stressed that in determining questions of criminal responsibility, the court should look at the provisions of the Queensland Criminal Code and not the doctrines of mens rea as developed under the common law of crimes. And the court stated as follows, quote, "It seems to us that the Queensland legislature have, by the express provisions of sections 23 to 25, laid down in clear terms what the law in future should be in regard to the very much debated, very much misunderstood, and very confused doctrine of what is referred to as menstrual, and directed that the court should not in future be guided by the conflicting and irreconcilable decisions of various courts on the question, but should be guided in determining the criminal responsibility of a person charged by reference to the tests prescribed by the language of these sections. So what the court is saying there is that when the question of what constitutes criminal responsibility, what constitutes no liability without fault, is to be determined under the Queensland Code, the court should make reference to the provisions of the code and not to the common law doctrines, common law doctrine of menstrual. The failure by Nigerian courts to correctly apply the provisions of the code to the question of criminal responsibility is illustrated by the decision in some cases treating section 24 of the criminal code as if it only provides for the defense of accident. Now, I've made reference to section 24 earlier. Section 24 is a provision that says, subject to the express provisions of this code relating to negligent acts and omission, a person is not criminally responsible for an act which occurs independently of the exercise of his will or for an event which occurs by accident. Now, that provision, as I have said earlier, is one of the key provisions on no liability without fault. Okay, and that provision is divided into two significant parts. The first part says a person is not criminally responsible for an act of omission which occurs independently of the exercise of his will or an event that occurs by accident. So those are two subsections of the same provision. So if the act occurs independently of the exercise of the will of the offender, then the offender has no fault, then the offender is not liable. If the act is an event which occurs by accident, then again, the offender is not liable because it is an accidental event. It is an accidental event. But the courts have not carefully and correctly applied these principles. For instance, in the case of Thomas against the state, the deceased accidentally hit the appellant's motorcycle, causing the appellant's daughter to fall into a gutter. The deceased apologized for the accident, but as he came out of his vehicle, the appellant slapped him and he fell and he hit his head on the road and subsequently died from his injuries. Now, the court found the appellant liable for manslaughter. And the basis for which the court found him liable was the comment by Eagle JSC, where the court stated as follows. The court stated that the defense in section 24 can only avail a defendant who can show that what he did occurred independently of the exercise of his will. But the court modeled the first part and the second part of the provision together. The court said, well, that the defendant was the one, or the appellant was the one that slapped the deceased, who fell down and hit his head on the road and died from his injuries. That act of slapping was a willed act. It was not an act independent of the exercise of his will. And therefore, the defense of accident did not avail it. But with due respect, the court muddled up the provision of the first part of the section 24 with the second part. Section 24, the first part says an act which occurs independently of the exercise of will, or an event which occurs by accident. Now, it is the second part that the court should have applied in this instance to evaluate whether the defense of accident avails the appellant. Section 24 covers more than the defense of accident. It is the second part that talks of an event which occurs by accident that covers the defense of accident. The first part, which talks of an act which occurs independently of the exercise of will, is similar to the defense of automatism under English law. Under English law, if the offender does an act independently of the exercise of his will and it occasions an accident, then the offender, it causes an offense, then the offender is not responsible. But the second part deals with an event which occurs by accident. Now, what is the event that occurs by accident here? The offender slapped the deceased, and the deceased fell into a gutter and hit his head and sustained serious injuries and died. Now, we could not have said that the appellant slapped him intentionally for him to fall into the gutter and for him to hit his head on the gutter and sustain grievous injuries and then consequently die. People don't ordinarily die from a slap. So the event that occurred is falling into the gutter, hitting his head on the side of the road, and sustaining very serious injuries was an event which occurs by accident. It was an event which occurs by accident. It was not an intentional act on the part of the offender. But the court did not correctly apply the provision of Section 24. The court did not correctly apply the provision of Section 24. You can also see the case of Brady against the state. Again, where the court did not correctly apply the provision of Section 24. The court applied the provision as if Section 24 only applies to one situation. Section 24 applies to two situations where the act occurs independently of the exercise of the will of the offender. That is the case of automatism. Or where the event occurs by accident. But the court in Thomas' case said, well, what happened was the offender slapped the victim. That his act of slapping the victim is a willed act. It's not an act that occurred independently. The court wrongly applied the provision. Because if the act occurred independently, the first part that deals with the act occurring independently of the exercise of his will does not apply in the instant case. The one that applies is an event that occurs by accident. If the event occurs by accident, the event can relate to an intentional act. It can relate to an intentional act. Okay? For instance, armed robbers try to break into your house. They shoot into your house. And you fired shots at the armed robbers. That's an intentional act. But an event arising out of that, your intentional act, can be accidental. If the bullet misses the armed robber and goes through the wall and kills your neighbor, that's not an intentional, that is an event that occurred by accident. And because it's an event that occurs by accident, it is not an intentional act. Your intentional act was to shoot at the armed robber. shooting at you through your window. Okay? But what resulted from your intentional act was an event which was accidental. So you will be entitled under the second limb of Section 24 to what is called the defense of accident. But the courts in the cases of Thomas and the state and Brady and the state mixed up the two provisions as if they related to the same set of circumstances. But in the case of Umoru and the state, Justice Uwaifo, who was then a justice of the Court of Appeal, correctly applied the provision. Now, the case involved a dispute between the victim and another person as to who has the right to park a car on a particular spot. Now, when the appellant went up to the victim, and then the appellant went up to the victim and slapped the victim hit his head on the third road and died from his injuries. Initially, he was convicted of manslaughter at the High Court. But the Court of Appeal, in a lead judgment delivered by Uwaifo JSC, allowed the appeal and discharged and acquitted the appellant under the second part of Section 24. And the court held that the second part of Section 24 covered a willed act. In other words, you did something intentionally, and what you did intentionally produced an event which is accidental. It resulted in something that you did not plan. It resulted in an event that is an accident. Okay, he slapped the victim quite all right. The victim hit his head on the road and died. His hitting his head on the road and dying is an accident. But because Justice Uwaifo was at this time, in the Court of Appeal, he had to navigate the case, his judgment clearly, so as not to be seen, to be going against the decisions of the Supreme Court in the earlier cases of Thomas and the state and Brady and the state, because those were decisions of the Supreme Court. But this was a correct application of the provision. Now, in Agua and the state, again, Justice Uwaifo clearly drew the distinction between the two arms of Section 24, as I've explained. The first arm relates to an act occurring independently of the exercise of will. That is the one that equates with the defense of automatism under English law. While the second part relates to the to what we call the defense of accident. So he clearly outlined the distinction between the two parts of Section 24. And in the case of Amayo and the state, Uwaifo, now a justice of the Supreme Court, authoritatively stated the distinction. Because now he's a justice of the Supreme Court, he can state the position clearly without running foul of the issue of judicial precedent. So he stated clearly that Section 24 covers two situations. The first one is an act that occurs independently of the exercise of will. That's the one that equates what happens under English law to defense of automatism. When you do something, in a reflex action, something that was done in a reflex action, while the second part relates to the defense of accident. And the second part can cover what the outcome of a willed act. So you will the act, you intended to do something, but it produces an event which is an accident. The fact that what you have done was intentional does not make you to be liable, because what occurred as a result of your intentional act was an accident. It was an event which occurred by accident. And your intentional act produced an event which is accidental. It produced an event which you could not have foreseen. It produced an unforeseen event. It is the unforeseen event that makes it to be an accident. So it's very important that Nigerian courts must, pay attention to the provisions of either the criminal code or the penal code when they are, determining questions of criminal responsibility, because it is very easy, to follow the principles or the doctrines of common law, under English law, and then model up the provisions of the code. Relates to defenses to criminal liability. The second part of the content of criminal responsibility relates to defenses to criminal responsibility. Now, there are, under the provisions of Chapter 5 of the Criminal Code, under the provisions of Chapter 2 of the Penal Code, which we have said governs generally the questions of criminal responsibility, those provisions outlines some defenses to criminal responsibility. So what we want to look at now is to look at those defenses generally and to look at certain common features to those defenses. Defenses to criminal liability may be premised on grounds of justification. So these defenses may be premised on grounds of justification. They may be premised on grounds of excuse or other grounds of impunity provided by the law. And once these grounds are established, then the defendant may escape criminal liability. In justificatory defenses, these are defenses premised on justification. The harm caused by the justified behavior remains a legally recognized harm, which is to be avoided whenever possible. Now, when the law justifies, provides, when a defense is based on justification, what that says is that the law takes the position that the claimant has good reason, has a permissible reason to carry out that conduct that has resulted in the offense. So his conduct is justified. His conduct is accepted by the law. His conduct is permitted by the law. So in justificatory defenses, the harm caused by the justified behavior remains a legally recognized harm, which is to be avoided whenever possible. The harm that is justified is still a harm. It's still a legally recognized harm. And the harm is to be avoided whenever it is possible to avoid it. But where the claimant is not able to avoid it, then the claimant is allowed to cause the harm. And when he causes the harm, the harm is, allowed under the basis of justification. Now, under the justifying circumstances, however, that harm is outweighed by the need to avoid an even greater harm or to further a greater societal interest. Let's take the plea of self-defense, for instance. The plea of self-defense that allows you to take the life of another when that other person is threatening your life and is creating in you a reasonable apprehension that is going to kill you or cause grievous bodily harm, and you have no other means of defending yourself other than to use proportionate force in response to overpower him and to kill him. So, your killing him is a harm because a human being has been killed. But that harm is outweighed by the need to avoid an even greater harm. The greater harm is the harm that is going to be caused by the victim now, who is trying to kill you without any legal basis. That is a greater harm than the law allowing you to use self-defense to protect yourself. So the harm of you, the harm to be done by you killing him is a lesser harm than the harm of his killing you. His harm of his killing you is a greater harm. And the law allows you to now kill him in return. Paul Robinson identified 3 types of justification-based defenses. Generally, lesser evils or choice of evil justification. In this type of justification-based defenses, the claimant had a choice between 2 evils and chooses the lesser evil. The example I normally give, to illustrate this is, imagine a scenario in which you are driving on the road and a toddler at a very short distance suddenly runs across the road, and you are driving at a reasonable speed, having regard to the volume of pedestrian traffic and the general volume of traffic on the road. So your speed was reasonable. But this young toddler suddenly is about to run across the road. So you have 2 choices. It's either you run him down and probably kill him, or swerve suddenly and maybe there is a carton of soft drinks or a pack of goods by the side of the road. So you have an option of running down the toddler or swerving suddenly and damaging the goods that are packed on the side of the road. Of course, the lesser evil in this kind of situation is to swerve suddenly, avoid the toddler, and probably damage the goods kept by the side of the road. The second type of justification-based defenses is the defensive force justification. Defensive force justification, where the law allows harms to be done for the purpose of defending self or property. I referred to this earlier. This involves weighing harm to be done by defensive force against harm to be done by not allowing the defense. Where threatened harm outweighs the defensive harm is allowed. This is usually the situation in which somebody is trying to attack you, and the law now allows you to use defensive force to protect yourself against the harm. Now, there are different degrees of defensive force that the law will allow depending on what is threatened. If your life is threatened, if somebody threatens to kill you in such a manner as to create apprehension of death in you, then the law allows you to use such force as may cause the death of the assailant. So the degree of defensive force that is allowed where life is threatened is very high. Where the property that is being threatened is a movable property, the law does not generally allow you to use a degree of force that may result in the death of the person threatening your movable property. But if the property is immovable property, if you are in your house and somebody is trying to set your house ablaze, then the law may justify you using such force that may result in the death of the assailant. The third category of justification defenses is public authority defense. Now, in this category, there is no requirement that the defense be triggered by threat. All that is required is that the actor is protecting or furthering a legally recognized interest. So if you are acting under public authority, then you have a justification defense. So whatever you do in the course of your exercising your public authority will be covered. The people who may come under this umbrella include law enforcement officers executing the law. So if a policeman in the course of effecting a lawful arrest assaults you, then you may have no cause of action against him. He will not have committed an offense of assault, provided that he uses such force as is reasonably necessary to effect the lawful arrest. Parents may also be covered by this, where they correct their children and use such force as not such as to cause harm to the child. Masters or educational institutions caring for a child using reasonable force to correct such child. One unique feature to all justification defenses is that they have the same internal structure. Justification defenses usually have a triggering condition. There's usually a trigger which permits a necessary and proportional response. In defensive force justification, the trigger is that somebody is threatening to harm you. Okay? In public authority defense, the trigger is that the person is exercising public authority. Maybe a law officer or a police officer trying to effect a lawful arrest. So there is usually a triggering condition which permits a necessary and proportional response. In defensive force justification, the assailant must have attempted to apply unlawful force to the interest protected by law before the claimant will be at liberty to use necessary and proportional defensive force. Now, if proportional and unnecessary force is used, the defense fails. Now, in defensive force justification, the law only allows the claimant to use proportionate force. If somebody assaults you by hitting you on the head with a ruler, you can hit him on the head in return with another ruler. The law will not allow you to bring out an axe and cut him on the head. That will be disproportionate use of force. And if disproportionate use of force is used, then the claimant will not be entitled to rely on defensive force. Based on the above analysis, the following defenses may be classified as justificatory in nature: self-defense, defense of necessity, public authority, discipline, consent, and superior orders. In excusatory defenses, there are some defenses in the criminal law that are premised on excuse. In excusatory defenses, the deed is wrong, but the defendant is relieved from criminal liability because conditions suggest that he is not responsible for his deed. Now, in excusatory defenses, the claimant is laboring under a condition, and that condition is such as to make him not to be fully responsible for his action, not to be blamable for his action. And in excusatory defenses, they have one internal structure. And that structure is that there is a disability causing an existing condition, which makes the defendant not a fully free and responsible agent as to be fairly held accountable. The offender is suffering from a disability from an existing condition, which makes him not a fully free and responsible agent. That's a disability. For instance, in the defense of insanity, the claimant is suffering from insanity. The claimant is suffering from a mental infirmity or a disease of the mind, which renders him incapable of being able to control his actions. Or in intoxication, the claimant has been involuntarily intoxicated. And by virtue of that intoxication, we cannot say that it's a fully free and responsible agent that the law should hold responsible. So examples of excusatory defenses can be found in insanity, can be found in automatism, can be found in intoxication, can be found in cases of subnormality or cases of immaturity where the offender is a minor. A minor is not fully developed intellectually to be able to know the difference between what is wrong and what is right. And therefore, because of that disability, the law cannot hold him responsible for his action. And whatever he does in that state, he will be excused from criminal liability. Now, most excusatory defenses completely exculpates the offender. It completely frees the offender from liability. The following are offenses where the excuse will only be partial. For instance, in the plea of provocation, as a defense to a charge of murder, if a defendant is able to establish that he killed the victim because the victim is he was a subject of grave insult, which provoked him and made him to lose his power of self-control and made him to kill the victim, then his plea of provocation may succeed and his liability for the offense will be reduced from murder to manslaughter. So the plea of provocation there, where it succeeds in the charge of murder, reduces liability from murder to manslaughter. There is also the partial plea of diminished responsibility. If the offender is not able to bring himself within the defense of insanity, but is still able to show that he labored under some form of emotional or psychological disturbance that affected his responsibility for the offense, he may be able to make a plea of diminished responsibility, and which the success of that plea will reduce his offense from manslaughter, from murder to manslaughter. So we have examined the